as this goes forward. I don't think the settlement fund should be set up this way. Did that case involve a president suing his own government and then settling that case before it could be reviewed or approved by a judge?
That's true. So it wasn't the case. The underlying case is not the same. The structure of the commission is the same as the Keep Siegel Commission.
Has it ever happened that a sitting president sued his own government for $10 billion and then directed the settlement of the case and the establishment of a payout fund?
Not that anybody can apply. The commission will set. The commissioners will set rules, I'm sure.
A $1.8 billion settlement fund. Questions about President Trump suing his own government. And now, Senator Chris Coons wants to know exactly where the taxpayer money could end up. His questioning of Acting Attorney General Todd Blanche raised some serious concerns.
I was pleased to see the president's message during Second Chance Month, where he said he wants to ensure those who take responsibility and seek to rebuild their lives have a chance to succeed. Senator Lee and I have a bill called the Safer Supervision Act. It's co-sponsored by Senators Tillis and Wicker, Kramer and Langford. It's got strong law enforcement and conservative support, and it fits squarely in that framework. Currently, federal supervision is imposed in nearly every case, leading to badly overworked federal probation officers who then can't properly supervise those who actually most need it. There's more than 120,000 people on average per year being supervised, and this bill would help ensure courts are more thoughtful, more analytic when deciding when to impose supervision. Is this a piece of legislation you can support?
So what you just said, I very much agree with. So without looking at every word of the legislation, there's no disagreement from me on a word you just uttered.
Well, thank you. I'd like to work with you on that.
Yes, I look forward to that.
Let me raise two questions. I've been gravely concerned about IP theft, especially from China, the whole time I've served. I was struck that the department's proposed budget cuts the funds for IP enforcement. Why? And is the department under your leadership committed to protecting American innovation?
Very committed. And while you're calling it a cut, Senator, I would say that it's a major focus of every...
It's a lack of an increase?
Well, no. I don't mean lack of an increase. I mean that we're focused on it at the U.S. Attorney's Office level. So when we take money and spend it around the U.S. Attorney's offices, and so it's baked into that big number, rest assured, every U.S. Attorney's Office, all 93 of them, are focused on the threats that we have from there. And so we're trying to spend our money more wisely.
Chair Collins raised a concern about the Violence Against Women Act funds. Let me raise a concern about the Victims of Child Abuse Act programs. Senator Roy Blunt and I worked to reauthorize this program. I've long been actively engaged with it. I've seen how children's advocacy centers in Delaware make a critical difference, bringing together law enforcement, mental health professionals to do child abuse investigations in a child-centered way to make sure children are not re-victimized. The number of victims served by these centers has increased fourfold over 25 years. Why are you proposing cutting this program?
So we have asked for $41 million for that program, and I agree with you, and I want to work with you to make sure that we're spending that $41 million where we should. I agree with you; it's extraordinarily important, and has had a lot of success over the past 15, 20 years as it's been up and running.
Thank you. Let me return to the line of questioning from the ranking member, Senator Van Hollen, that I strongly agree with. I'm just looking at the settlement agreement in Trump versus IRS. And I just want to make sure I heard you properly when you responded previously. Your announcement said that the fund will send you quarterly reports. Will you commit to making these reports fully public so Americans know who's getting taxpayer dollars out of the settlement fund? This says they'll be confidential. This is Section 4, Part E of the settlement agreement.
The reason why I want to be careful in my answer is because there's obviously laws that exist around privacy that may prevent some of the information that the commission takes in from being fully public. Beyond that, there will be full transparency, and I commit to you that, beyond the applicable laws that exist around privacy and privileges and whatnot. But as far as being transparent and having those quarterly reports released, yes.
Thank you.
By early August, the $1.776 billion Anti-Weaponization Fund had been formally terminated by the Justice Department. Republican Senators John Cornyn and Tom Tillis had demanded a binding commitment from Blanche to kill the fund before supporting his nomination. So the quarterly reports Coons was asking about became a much bigger question. The fund itself ultimately didn't survive.
You referenced a previous case. I think it was Keepsiegel versus Vilsack under the previous administration. Did that case involve a president suing his own government and then settling that case before it could be reviewed or approved by a judge?
So no, neither does the commission.
It did not. And so when you suggested that they're nearly identical, they're not identical. I think there's a critical difference here. President Trump is the first president to sue his own government and then direct his chosen acting attorney general to reach this kind of settlement. Will you commit that none of President Trump's family will receive a direct payout from this fund?
Well, yes, but what you just said is not true. I mean, if I can correct that.
Please.
The president did not direct me to do anything. And secondly, when we said it was that the structure of the commission is similar to Keepsiegel, that's true. It wasn't the case. The underlying case is not the same. The structure of the commission is the same as the Keepsiegel commission.
Has it ever happened that a sitting president sued his own government for $10 billion and then directed the settlement of the case and the establishment of a payout fund?
Not that I'm aware, but there's a lot of things that President Trump's the first of. No president had been indicted 1, 2, 3, 4, 5,
Correct.
6, 7, 8 times either.
Correct. No president's been indicted. And will you commit that none of this money will go to President Trump's campaign donors?
I am not committing to anything beyond the settlement agreement itself. When you say campaign...
And this is where the story took another major turn. In August, Blanche formally rescinded the $1.8 billion fund, but he did not completely undo the controversial tax provisions benefiting Trump, his sons, and the Trump Organization. The latest reporting says those protections remain retroactive, meaning past tax claims are shielded, while future tax filings are not covered. Trump has also continued defending the fund even after the Justice Department moved to terminate it.
Campaign donors, that they are not excluded from seeking compensation.
Last
if
question.
Weaponized.
During Police Week, I heard from a number of law enforcement friends who found it appalling that there was the possibility that folks like the Oath Keepers, the Proud Boys, who had assaulted Capitol police officers, could receive multi-million-dollar payouts from this fund. Will you commit that no one who has been convicted of assaulting a police officer will receive a payout from this fund?
So I shared the concerns that apparently members of law enforcement gave to you last week, although none of this was announced last week, so that's surprising. But
they had heard rumors there would be a settlement fund.
Okay, but anybody can apply. The commission will set. The commissioners will set rules, I'm sure. That's not for me to set. That's for the commissioners. And whether an individual, an oath keeper, as you just mentioned, applies for compensation, is anybody in this country can apply.
Well, we'll be watching this very closely as this goes forward. I don't think the settlement fund should be set up this way or for these purposes.
On August 3, 2026, Acting Attorney General Todd Blanche formally rescinded the Justice Department order that had created the nearly $1.8 billion Anti-Weaponization Fund tied to President Donald Trump's lawsuit against the IRS. The move came after Republican Senators John Cornyn and Tom Tillis demanded stronger action before supporting Blanche's nomination. Blanche also clarified that the separate tax audit protection for Trump, his sons, and the Trump Organization applies only to past tax returns rather than future filings. But the controversy raised at the May 19, 2026 hearing was not completely resolved. On July 13, 2026, a federal judge ruled that Trump's $10 billion IRS lawsuit had been improperly used to obtain personal benefits and prevented the purported settlement from taking legal effect in the case. Despite that ruling, the Justice Department continued to maintain that the separate tax immunity arrangement remained in effect. Then, on August 8, 2026, the Senate narrowly confirmed Blanche as Attorney General by a 50-49 vote. The latest dispute therefore centers on whether the tax immunity provision can legally remain in force and whether Congress needs to permanently prevent a similar arrangement from being created again. That latest history makes Senator Chris Coons' questioning of Blanche on May 19 much more significant. Coons was not simply asking about a normal Justice Department settlement. He was testing whether the department could create a mechanism involving billions of taxpayer dollars while the underlying dispute involved the president himself. The unusual feature was the overlap of roles. Trump was the plaintiff, the federal government was the defendant, and the officials negotiating the settlement ultimately worked within the administration headed by Trump. Blanche pushed back against that characterization. He said Trump did not personally direct him to take the actions and argued that the structure of the compensation fund was comparable to arrangements used in an earlier case. That distinction matters. The administration's position was essentially that the government was resolving litigation and establishing a mechanism to compensate people who believed federal agencies had been used against them. From that perspective, the issue was about correcting alleged government abuse rather than giving the president personal money. But Coons focused on the safeguards. He asked whether Trump's family could receive money from a fund, whether campaign donors could benefit, and whether people convicted of assaulting police officers during January 6th could apply. Blanche would not make the blanket exclusions Coons requested. Instead, he said the commissioners would establish the rules and that anyone could apply, subject to those rules. That is where the hearing exposed a major weakness in the arrangement. The definition of who qualifies for compensation was not clear enough. A fund approaching $1.8 billion cannot simply rely on broad promises of transparency. It needs objective eligibility standards, independent oversight, and a process that prevents political connections from becoming a factor in deciding who receives taxpayer money. Coons also asked Blanche about quarterly reports. Blanche committed to transparency, while acknowledging that privacy laws and other legal restrictions could limit what could be released publicly. That commitment became important because the fund was not ordinary appropriations. It came out of a settlement involving the federal government and the president. The more unusual the mechanism, the more important public oversight becomes. The later developments show why those questions mattered. Blanche eventually rescinded the fund after Republican senators made it a condition of moving his nomination forward. That is a significant reversal from the position examined during the May hearing. But the tax immunity portion was treated differently. Blanche's August order clarified that the mutual release applied retroactively, while the administration continued to defend the protection for past tax matters. Then came the July court ruling. The judge concluded that Trump's lawsuit had been used for an improper purpose and that the settlement could not simply be treated as a legitimate resolution of the case. That ruling is especially important because it challenged the basic legal foundation behind the arrangement, rather than merely criticizing its political optics. At the same time, there is a legitimate argument from the administration that should not be ignored. If federal agencies were genuinely weaponized against Americans for political reasons, the government should have a way to investigate that misconduct and compensate legitimate victims. Government accountability should not depend on whether the people involved support or oppose the president. The problem is the structure. If the government creates a compensation system in response to a lawsuit brought by the president against his own administration, the public needs to know exactly who controls the money, who qualifies, who audits the program, and what prevents the next president from creating an even larger version for political allies. The strongest criticism of the arrangement, therefore, is not simply that it benefited Trump politically. It is that it blurred the line between legitimate government compensation and executive power being used to resolve a dispute involving the president's own financial interests. And the strongest defense is not that the president deserves special treatment. It is that allegations of government misconduct deserve a meaningful remedy, and the government should not be allowed to ignore people who were genuinely harmed simply because the remedy is politically controversial. That leaves Congress with a larger institutional question. The fund has now been rescinded, Blanche has been confirmed, and the courts have already rejected the idea that the original lawsuit can simply be treated as an ordinary settlement. But the debate over the tax immunity provision is still alive. Ultimately, this hearing was about something much bigger than Todd Blanche. It was about whether the Justice Department can maintain public confidence when the interests of the president, the IRS, the Treasury Department, and political supporters intersect in the same legal dispute. If the government is going to compensate victims of alleged federal misconduct, that process must be independent enough that Americans can trust it regardless of who occupies the White House. The question now is, should Congress permanently prohibit any sitting president from negotiating a settlement with his own administration that could affect his personal tax liabilities or benefit people connected to his political movement?